When a defendant's on trial in a criminal case, it's usual for a judge to let the defendant wear street clothes during the trial. That's because if a jury sees a defendant on trial in a criminal case wearing a jail outfit and handcuffs and shackles, they'll look at this guy and think, man, that's a truly violent offender. That's what we call prejudice in my profession. Now, the judge for the defendant in the Charlie Kirk murder trial is actually taking that concept a little bit further. Not only is the defendant being allowed to wear street clothes during the trial in front of the jury, he's been allowed to wear street clothes in all the public pre-trial conferences and hearings, and that's due to all the media coverage. In addition to that, he's not going to allow the media to have any photographs or video of the defendant in handcuffs or shackles. So, is this a case of a judge going too far to protect the rights of a criminal defendant? Join me in a legal deep dive in the wardrobe legal issues of the defendant in the Charlie Kirk murder case. What's good, people? Well, I hope you all had a great Thanksgiving. We actually did something different this year. We're normally the host family, which means my wife and I have everybody over at our house. We buy all the food, she does all the cooking, and everybody comes to our house for Thanksgiving. Well, this year we went to the beach. And what happens is, for all the host families out there, you know how much work it is when you're hosting the holiday meals. It's like 4 days. You spend the day buying all the food, getting the house ready, you spend the day doing all the cooking, you spend the day having everybody there, everybody has a great time. Of course, nobody does any work or helps clean up. Then everybody goes home and you spend the day cleaning up. And it's just a lot of work. So, and on top of that, as the kids get older, it just gets more difficult to round everybody up. They have their own lives, they're working, they're doing other things and making other plans, and they're kind of coming in and out. So it's really not the same. And ultimately, the juice isn't worth the squeeze. So this year we got a place to the beach. We're going up there. We told all the kids, hey, we're coming to the beach. We're going to the beach this year, and you're welcome to come. But if you come, don't expect a big plate of food to be ready for you. It's BYOT. Bring your own turkey. All right. Now, before we get into it, do me a favor. Go ahead and like and subscribe to the podcast so you get all the legal updates. Now, although the trial for the man accused of murdering Charlie Kirk hasn't started yet, the case is actually still drawing some attention based on an interesting ruling the trial judges made. As I said earlier, it's very common for a judge to allow a defendant to wear street clothes once the trial starts and the jury's present, but this judge is actually taking it to another level. This judge is concerned that due to the media coverage, the defendant can't get a fair trial. So he's actually allowing the defendant to wear street clothes in all the pretrial hearings, even though there's not a jury present, because he's concerned that if the media broadcasts photos of him in his prison outfits, then the jury watching at home may be prejudiced and hold that against the defendant during the trial. And to take it a step further, although the defendant's going to be kept in shackles and handcuffs in all the proceedings, he has barred the media from taking photographs or video of the defendant depicting him in any type of restraints. I know that some people think this is just another case of the judge giving the criminal more rights than the victim, but this is just something that's very common. It's very common for defense attorneys to try to have their clients looking more presentable at trial. I actually had an experience that was disturbingly horrible myself with a criminal client I represented. I represented this man who had some mental health issues, but he was fine. I mean, he came from a nice family. They had money, but he had some mental health issues. He actually lived in a storage unit. He never took showers, and he walked around with this brown paper bag with this big giant grease stain on it. I don't know what was in it. I didn't want to know. So anyway, this guy gets arrested on some bullshit trumped up charges, probably because they just made some people uncomfortable. But he truly, in my assessment, should not have been arrested. But he got arrested, he's facing time. His family actually pays me good money to represent him. And this is a case that I know I could have won at trial, but for the fact that I know my client could not just sit there at the defense table for 3 days and look normal. He just couldn't do it. And I just knew a jury would look at this guy for 3 days and go, we're convicting him of something, you know. So I cut a deal. He was very happy with it. It was a reduced charge. He had a 99% chance of getting probation, and he was ecstatic about it. So I'm trying to do my part. I give my client some money. I say, look, here's the deal. Take this money. Don't sleep in your storage unit. Get a hotel. I bought her some clothes. I said, wear these clothes. Get a good night's sleep. Meet me in the courtroom tomorrow. And for God's sakes, do not bring that brown paper bag with the grease spot. Just do that. And I felt very good about it. Of course, he shows up to court the next day wearing the same dirty, smelly clothes and just said he didn't want to sleep in the hotel. He wasn't comfortable with that. That's not him. And of course, he got that big, nasty brown paper bag with the grease spot. So I'm like, wonderful. We're about to go in front of the judge, but hey, I keep a cool head. I said, John, just focus on what you can control. And I talked to my client and said, listen, for 15 minutes, just stand there and say nothing. Let me do all the talking and you will walk out of here. I gave my presentation, no prior record, all the mitigation. I hit all my points. I felt really good about it. And then the judge looked at my client and said, okay, is there anything you want to say? And then the wheels fell off. My client went on a 30-minute manic rant about God knows what. And I'm standing there helpless. The courtroom is looking at him, everyone looking at him like this dude is just insane. And I had to kind of just stand there, emotionless face, no expression, and wait for him to finish. And judge said 10 years. So, I mean, that's what happened, So point is, you definitely want your client, your defendant to make a good impression in court, because although this case is a case that should have got probation based on his manner, based on how he looked, I mean, the judge thought this guy was probably a dangerous, violent person, and he really wasn't. But that's what can happen. But I digress. There are actually a lot of cases where defense attorneys try to do a lot more to clean up their clients besides just, giving them a fresh set of clothes. There are a lot of cases around the country where, defendants have had all these face tattoos, swastikas, words like baby Nazi, I'm a killer. They have these face tattoos, and of course their attorneys want to have their tattoos covered up during the trial. In some cases, they want to just do makeup, which are the basics, but there are actually cases where the defense attorneys actually try to get the court to pay to have the tattoos removed. Now, as you can imagine, the prosecutors always object to things like that. They say, hey, let the jury see the defendant for who he is. If that's who he is, the jury needs to see it. But really, that's not how it's supposed to work. They should want the jury to convict the individual based on the evidence, not based on the tattoos. The only thing I would say is relevant is if the tattoos are somehow relevant to the defendant being identified at the crime. I mean, if they see a suspect at a murder scene and he's got a big SpongeBob tattoo on the side of his face, then yeah, the jury needs to know that's the guy, because I know it's the guy because he had the big SpongeBob tattoo on the side of his face.
Ready for action! Bark, 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 bark.
I gotta call it like I see it. On this case, I don't have a strong opinion either way on the restraints. On one hand, yeah, you want the defendant to have a fair trial, but I do think it's kind of overboard for the judge to allow the defendant to be, dressed out in pretrial hearings when there was no jury present. And I think it's overkill for him not to be photographed in handcuffs and shackles. I mean, I don't think that would prejudice him. If anything, I think if the public saw him in court and he wasn't handcuffed and shackled, and considering he's charged with murder, they would think that everybody's crazy for not having this guy in handcuffs or shackles. So on the other hand, the prosecutor, while of course they're going to object, that's what, that's their job to represent the state. But if you're really worried about having to have a defendant seen in handcuffs and shackles in order to get a conviction, then you need to really reconsider your evidence in the case. So that's what I think. You might not agree. You might like what I'm saying. I really don't give a damn. Either way, do me a favor, share this podcast with someone you think might find it interesting, and post your comments and call it like you see it. That's it. Well, that's all I got, but I do appreciate you taking the time to join me on this legal deep dive. I think it's always fun to discuss these topics, tell you what I think, and get your feedback. I would really appreciate it if you took the time to like the video, subscribe to the podcast, and also I'd appreciate you sending me your comments so we can discuss the topics you want to hear about. That's it.